Good morning, everyone. My name is Rob Litz with USA&M. It's our pleasure to present these best practice programs as we have over about 15 years or so. Today is our 79th best practice program. We have a fabulous lineup of folks to speak. Initially, we're going to do a program we've never done before, resolving family law disputes through the arbitration process. The presenters are two outstanding practitioners in the family law area, Ann Bauer from the Center of Family Law in Clayton, and Carrie Mogerman with the Carmody McDonald firm. I know they have taken special training in arbitrating those types of disputes and are going to share a little bit about this, frankly, cutting edge area to resolve disputes in the family law area. This first program will go until 10 minutes to 10. We'll take a short break, but I welcome all of you and thank you for attending this morning's best practice program. Ann and Carrie, the floor is yours.
All right.
Thanks, Rob. Good morning, everyone. And Rob, thanks for the privilege of speaking to this group through USA&M. And we want to also thank Kelly Spiller, who helped us with all the logistics. And Ann and I come to you this morning with the question, is arbitration the next big thing in ADR in family law? It's an interesting topic from our perspective. We're humble people, and so when Rob says we're speaking at a program this morning about best practices, we'll tell you that these are pretty good practices. We're still honing them, and but we're very interested in the topic, or have become very interested in the topic, and we're happy to address it, and we appreciate the opportunity.
And I have to add that I appreciate Rob said we will share a little bit of knowledge.
Yes.
Thank you.
And I think you'll all conclude that that's exactly as promised. So is it an idea whose time has come in Missouri? I know that we're speaking to an audience of arbitrators and mediators, so we'll not belabor too much of your time with the history, but just looking back, we have an act in Missouri based on the Uniform Arbitration Act, and we've not adopted the revised Uniform Act. But since the time of our enactment, the family law community has taken a great interest in arbitration as a method to resolve these disputes or parts of these disputes. In 1999, North Carolina became the first state to adopt a family law specific arbitration act. And that act was based on the RUAA. And then since '99, the American Academy of Matrimonial Lawyers, an organization that both Ann and I are fellows of, adopted its own model act and propounded it with comments. And both of those acts are in your materials. And the Uniform Family Law Arbitration Act at page 23, and then the Model Act of the AAML at page 143. So we have not adopted in Missouri either the Uniform Family Law Act, but we have an interest in it, and perhaps you will also. As you know, our state enactment is very broadly written, and it was written before a great body of jurisprudence, case law from our courts of appeal since, because you know, the act that we have in Missouri states that if an arbitration award in any proceeding addresses a child of the marriage, that determination shall be subject to de novo review. So it seems clear that when the act was originally contemplated, it was thought that family law matters might also be arbitrated. Although, as we footnoted in the materials, we think it's rather difficult to do in Missouri with the cases that state pretty clearly that the court cannot impermissibly delegate its important responsibility to address child custody issues. But that's the current state. And around the country and here in Missouri also, we have a special master rule. There are other states like California where we know that private judging is what they call it there, is very commonly used, but not so much in Missouri. So why?
Looks like we just lost the feed from Carrie. All right, we will wait a few minutes. They should be dialing back in and joining us in just a minute. I appreciate your patience. While we are waiting for Carrie and Ann to rejoin us, I wanted to mention just a couple of things about our upcoming programs this fall. You may want to jot down on your calendars, November 18, a Thursday morning, we're going to do a half-day program. That program is going to cover the area of sports law. Bob Wallace, Hal Welford, and perhaps some others are going to join in a roundtable discussion about the intersection of the world of sports and law and alternative dispute resolution in that area. We're also going to be thrilled to have back a session on an update of civil law. Steve Ringkamp from the Hulverson firm has been kind enough over the years to put together outstanding materials reviewing updates of civil cases over the past year, and has agreed to join us on November 18. The third program that we will have will include an ethics program. So we'll have an hour of ethics, an hour on a civil update of Missouri civil cases, and then a program on sports law with Bob and Hal Welford. Hopefully we'll have Carrie and Ann rejoining in just a couple of minutes. And I see that they are coming in right now.
We're sorry.
I don't know why we dropped, but
Not a problem.
we just flat dropped.
That's not a problem. Okay, welcome back.
Thank you.
The floor is yours.
Okay,
We're
so
done.
we lost our train of thought. We're done. So anyway, I guess I will comment on Missouri. We have mediation seems slower in Missouri to take off in family law areas, and it has always concerned me when I talk to family members or meet people across the country. It's like, you're going to mediate your custody, period, the end, in family court in other states. And it's not just go in one time, they will just work with the mediator till they're done. We just got a local St. Louis County court order requiring people to at least consider the mediation and file something with the court to let the court know if they are proceeding in mediation or have a reason not to, such as settled the custody already, or some other reason that the person, one or the other, will not mediate. In terms of other things that people have tried in terms of ADR here, the parenting coordination, and we'll talk about that a bit more later, but that's also been a struggle within the state of Missouri. And we have parenting coordination in certain counties, but not by statute. And I think a lot of it just goes back to the judges want to have the final say on everything. And which is interesting because so many of the judges say, I don't want to deal with custody.
Work it out.
But somehow they aren't giving their authority away at this point in time. So why are these cases different? And Carrie, I think, said it best when we were chatting about how we are an ever-moving target when we're doing a family law case. People have to spend money. People have to take their kids to school. They have to maybe figure out ways to divide up money to households. And so it's not stagnant the way general civil cases are. And there are many, many issues. It's not just come in and how much do I owe you?
Right, in the sense of a commercial dispute where there was an occurrence or a contract breached or something like that, or an injury case where there was an accident. The occurrence happened and that's it, and the facts remain the same from the day it happened until the day of trial. Now, they may be reported differently, but those are the facts. But in our cases, in these family cases, the marriage continues to exist. The organism that we're addressing continues to exist, and changes continue to occur throughout the life of the case. It's sometimes very difficult to get in to see a judge when you may need to see him or her, when something has happened that is significant relating to the funds of the parties or the children of the parties or whatever. So that's a significant difference. And I think that may be one reason there has been a great deal of interest that has been coalescing about a specific family law arbitration statute. The one I didn't mention, I think, was the Uniform Family Law Arbitration Act that in 2016 was propounded by the National Conference of Uniform State Law, National Conference of Commissioners on Uniform State Laws, the NCC-USL. So we have now 3 model acts, really the North Carolina Act, which was the progenitor of the Family Law Arbitration Act, then the AAML's Model Act of '05, and then the NCC-USL's Model Family Law Arbitration Act.
Promulgated is they are still playing off the Uniform Arbitration Act. They didn't want to reinvent wheels that didn't.
Well, it looks like the Carmody McDonald firm may not have paid their fiber optic bill this month for internet. We will get back. Oh, there they are.
We're back. We're sorry.
Okay.
I don't know what's happening. And
I would like to repeat that I am at the Carmody McDonald offices.
The Center for Family Law really has crummy internet, apparently.
Oh, is that? Yeah, that's kind of true. I know.
We're gonna pretend we're on whether we are or not.
So the Family Law Act of arbitration is going to be very specific to the needs of family. And I guess that I think is very important for us. If we're not going to get that in Missouri, we at least, as people entering into arbitration, need to look at those acts and see how we can use the uniform acts in order to create the system that we're going to arbitrate in.
So why would someone want to arbitrate their family law dispute? Well, there are really many reasons. You know, we are still we're still dealing with a rule, open courts, and so these disputes are heard in open court. Parties may have particular reasons not to want their dispute heard in open court. They may, as occasionally occurs in a complex financial case, there may be tax issues that they don't want to address in open court. They may have specific competitive business information that they don't want to discuss in open court where the court is accessible and the information in the hearings is accessible to others. They may have health issues or mental health issues that they don't really want to address in open court. And the form of arbitration allows that confidentiality to take place away from the court while still allowing a full judicial hearing with direct and cross and evidence and everything else. Another reason may be, and as we mentioned, this organism continues to exist for a year, maybe 2 years, maybe more, if you add an appeal. The agreement to arbitrate should specify when the arbitration award is to be issued. And so the parties have an interest in the contractual availability of an ending date that they know and that they can predict and specify in negotiating the arbitrating agreement with the arbitrator. So that's another reason that arbitration may be of interest. It's flexible and it's much more informal. That doesn't mean rules of evidence may not still apply or rules of civil procedure, but certainly it is more comfortable to be in the conference room or some neutral place, maybe that's not the court and there aren't third parties milling about, while your personal information and most important information is being shared, discussed, put forth, and attacked. So the flexibility and informality of it is very appealing, I think, to families. It's not, of course, mediation, and we all understand what the distinctions are, but I would submit to you that the lay public doesn't. And Ann and I have people in every day who say, well, why can't we just go to a mediator and have them make the decision? Right. So they don't understand the distinction. And so if they understand that they will have finality, I think it's attractive to family law litigants. And although like court, we can confine the arbitration to a rather narrow set of issues. We can specify that which will be arbitrated. We can specify that which will be mediated, and we can specify that which will still be heard by the court. Lenny asked if we could distinguish the use of arbitration from the appointment of special masters under, I think it's Rule 68. And they're very similar. I agree, Lenny. They're very similar. The distinctions that we came up with, batting it about, are first of all, the negotiation of the arbitration agreement really is a private contractual matter between the parties and the arbitrator, whereas the order of reference is frequently drafted by the lawyers who asked for the order of reference, and so it's similar. But sometimes the court may have its own motion order reference to a special master, and the parties I don't think have the opportunity to negotiate that order of reference. I suppose the master may determine the responsibility for payment if the master is given that authority, how the master will be compensated for his or her work. But in the arbitration agreement, the rule and the AAA rules say that we can say, unless otherwise agreed, the master. Now I'm confusing the two rules. The arbitrator can determine how payment shall be made for the services of the arbitrator. And that takes us to economics.
Yes. Is it too expensive? Well, one of the things that comes to mind is I had the privilege, which is why I ended up going to the training to be arbitration trained. I was selected for a 3-person arbitration panel a year ago. We finished up just before the pandemic, and I was just saying to Carrie, if we hadn't gotten that finished, who knows what would have happened. But we had a very specific, it was on a premarital agreement. It was a very, very specific question, but it was complicated. And we had opposing experts and we had the parties, and we scheduled 2 days of arbitration and finished in 1 day and a few hours. And I think all of us that were involved, the attorneys and the arbitrators, were like, how did that happen? go to trial and you don't finish that day and somebody says, come back in 6 weeks, see if you remember anything, see if the judge remembers anything. So being able to put something into a compact time can actually save a lot of money from coming back to court over and over and over again. I just saw something get changed from an October trial date to a May trial date on a case I'm involved in. And yet what happens in that time? We talk about the living organism of the divorce. There you have lots of problems. So the fact that you can do something in that kind of a short time frame and control the trial, and part of the reason that took less time, and you can make it very informal, our experts came in, sat across the table from everyone, explained what they had done, what their investigation was, what they thought, and then we were able to so much better than going through a tedious trial of putting everything on for the judge. Trial days in arbitration are set, as I said, and if you go to court, it may be that somebody comes trooping across, whispers to the clerk, who whispers to the judge, and all of a sudden there's an hour recess that we were told was a 10-minute recess. So you get rid of all of those kinds of things. And so even if you can't arbitrate custody and support, you can get so many other things done that it takes less time for the trial. You also can have it less expensive just because you're getting it done sooner as opposed to dissipating assets all around, for all the months. Also, I think that probably once you've arbitrated, let's say you don't arbitrate the whole case, you've decided you're going to arbitrate something interim, and people like how it got handled, and then they hear that the judge can't see them until December and it's August, then maybe they say, oh, why don't we arbitrate this other piece? And they may even decide that they can go sit at a table and mediate, maybe.
Yeah. And when you think of the scope of responsibilities we place on our courts, they're to hear cases, they're to manage the operation of the courts. They're right now trying to manage keeping the public safe from infection and court personnel safe from infection while moving these dockets as well. It's really, it seems an almost insurmountable task. And so the option of sending a case where like-minded parties have already agreed, let's arbitrate it, let's send it out, and let's get an 8-hour, 9-hour hearing day if we need it, or we don't have to worry about probation revocations being heard over the noon hour, or
Weddings.
Wedding Wednesday, any of those things. So those are, I guess our point is, there is of course an additional cost to hire the arbitrator, but we think that the efficiencies that you pick up through the process really may significantly outweigh that additional outlay to the parties. It's not for everybody, but there are many parties who can do it and would like to do it. And the Model Acts specify that unlike the AAA, unlike the Uniform Act, where you can have a 3-arbitrator panel, and the rules allow for that, the Model Acts say the default should be a single arbitrator that's agreed upon. Certainly you can have multiple arbitrators if that's agreed upon. And we've both commented before the meeting that we both have prenuptial agreements right now in our office that were drafted a few years back, which specify use of the AAA rules and a 3-arbitrator panel. But that is really expensive, and maybe that should be addressed in your arbitration clause that Ann will discuss later.
Mm-hmm. I also have thought, because even though it would be nice if all of our clients were high end, sometimes we represent middle class people. I thought about some of the cases I've had where we got pushed around to the judges so long, and then it gets to be December and then you get a new judge. And I think you could probably, if you started early, you could decide to arbitrate a much lower income family than we think of when we think of hiring a private judge, and get them in and out and done sooner. And sometimes just going back and forth between the attorneys doesn't always work when the clients are so emotional. You put them in front of the arbitrator and say, that arbitrator is going to make that decision. They may save money even
That's true.
then. I think it's quite possible.
So we know we're probably preaching to the choir on that, but I would suggest that it's an even more acute need for arbitration in these family law cases than in commercial or other cases that you may be arbitrating in your practices. So one subject that comes up is, can we have the same person be our arbitrator, but also be a mediator? And that is a subject of some dispute in the Family Law Committee, and I don't know how the arbitration community and mediation community in general addresses it for other disputes. It's permitted in family cases, but it's probably not recommended. Well, why is that? Several reasons. First of all, if I'm going to try the case against Anne, and she's a very wily opponent, if she has revealed something to the person who's going to hear the case in a mediation caucus that was confidential, and I don't know what she revealed, I may not ever have the opportunity to know about it or respond to it, which I think puts me at a little disadvantage, which I'm already at, number one. Number two is concerns about the loss of confidentiality that she would otherwise have been afforded, she and her client, through mediation. If we're going to arbitrate the thing after an unsuccessful mediation, maybe that confidentiality has been lost, and it's been lost to her detriment, because she said, I really don't need that much maintenance for that. And that if we're going to have full disclosure, that's going to be an admission. It's going to hurt her ability to move forward with a maintenance case. So there's also a little bit in the writing that we have read and studied about this, a little bit of a risk of coercion. The mediator is a neutral, the arbitrator is a neutral. If the parties aren't always aware of the difference in those roles, as we mentioned, and so there's a concern that the party may not be fully aware that the information they're sharing in confidence is going to, or that they don't want to share, is going to come up in the hearing. So informed consent is critical if it's going to be contemplated, and the best practice seems to be that informed consent should occur only after the dispute has occurred. It shouldn't be included in an arbitration provision in some agreement that is written that contemplates arbitration in the future if there's a dispute. That today, as we sign this agreement, we agree that if we ever arbitrate it, we'll also use the same person for a mediator. That's not really informed consent. Once the dispute arises, the parties can have separate counsel and then get the necessary informed consent that's really critical to proceeding with a combined role. I think we've bounced it around, and I don't think either one of us think it's advisable, but it does come up, and
yeah,
it's contrary to that efficiency argument we were making. But
well, and some of the judges, actually, that's what they are. They're sitting there in a settlement conference suggesting ways you can settle your case, and many judges are hesitant to be helpful in that way, which usually it is helpful, because they don't want to have somebody think they have pre-decided a case. And other judges some judges just won't give you the information or the help you need to settle. And I think you get the same place if you're trying to do med-art, where there's a concern about what has the judge heard in chambers and how does that impact the decision, and what has the mediator before they are an arbitrator heard. So I think, the other thing is with mediation, I feel like we're trying to be creative. When you think about mediation, you think about, we're reaching an agreement. We are going to work to reach that agreement. We are going to try to be flexible, and we don't have to follow the law. People come in and they decide what they're going to do in a mediated agreement may not be what a court would do. And so it's a whole different attitude than when you go and say, okay, we can't reach agreement, please make a decision. So that's how I feel about having one person do a dual role, not a good plan.
And you probably, just as you're looking for trouble if you don't have a fee agreement or you don't document your file, if you did have a combined mediation arbitration, you probably are unwittingly increasing the likelihood, or at least the possibility, that the award may be vacated because of that. If a party feels that the arbitrator was not impartial or that the information was tainted because of that communication.
I'm looking at this question up there. The Colorado comment. Yeah, I don't know if that is in reference to a parenting coordinator. But there's a lot of, and I think we've got that later in our outline, a lot of custody that is determined later that they have. When they put their judgment in place, they appoint what's called a parenting coordinator. Colorado was one of the first states to have it. And that person, and in Missouri particularly, but I think in general, a parenting coordinator cannot make the real substantive change of, oh, residential parent is now going to be the mom, or primary custody is now going to the dad. I can't do those kinds of things. Can't say you were going to get a week of summer vacation and now from every year going forward, you're going to get 6 weeks. But they can help people adjust if they're fighting over something overlapped. Believe it or not, we can draft those parenting plans over and over and read them, and our clients approve, and they sign a parenting plan, and then 2 months later they're calling you and saying, doesn't say anything about this, doesn't say anything about the fact that my child's birthday is on a holiday. So you have times when the parenting plan is not enough and the parenting coordinator is often used as an arbitrator, and that is actually a MED-ARB model, which is probably different because they're not deciding long-term legal custody
Right. But it's also
designations. They're making
also
decisions.
an agreed upon disposition,
Yes, it
right?
is.
It can't be imposed by the
Yes,
court.
right. And they can't change legal custody, but when the parents disagree on a big decision, they can make the decision. We might do arbitration. Well, we are very fortunate here in our community that we have several retired judges who have significant experience in family law, and they have been doing mediation that's in a different model than most family court mediations, which most family mediations are the mediator and the parties, and they work separately. You can have your legal advice, but you're not all attending the same meeting. I think these judges have either started doing arbitration or they're doing a more civil-like mediation with the family. And I think it's great because then the attorneys are there and the attorneys hear their clients and the attorneys hear the same information, and they're doing more of a maybe, and they could move into arbitration, not that you and I want them to, but they're much more,
But they're used to it.
but they're used to it. They're much more likely to give an opinion that you aren't going to get from the standard sit in the room with just the mediator opinion, because the mediator is truly trying just to work the parties towards the agreement.
And the additional appeal for them is that they have the substantive knowledge of family law
Right.
from having heard so many cases. So there are a number of them who will hear these cases.
The other piece is, in terms of pro arbitration, is we don't have judges who apply to be a family court judge in Missouri. And until we do, you don't know if your judge is going to even have the knowledge base to decide a complex issue, or the interest, decide some of these issues. Sometimes we get people in the family court who have never done a family court case as an attorney, and they get up and running and they learn what they need to learn, and they rely on the family bar to help them, and they do great. But not all of them do, and some of them are just not as interested as others. So another reason to try arbitration. I guess I shouldn't say try, because once you do, you got a contract
Stuff with it.
and you're doing it.
So just for a moment, comparing the model acts to our state act that we're using, of course, it's very broadly written, very broadly, and it's not specific to the family laws. The uniform acts address custody disputes, and they identify those which should not be arbitrated. For instance, guardianship decisions, adoption decisions, termination of parental right decisions. The uniform acts proscribe those matters from being heard in arbitration. And those acts include provisions for arbitrating child custody disputes. And of course, another reason for a specific family law arbitration act is the fact that there are the modifiables. Custody is always modifiable after its determination. Child support, spousal support where modifiable. So the typical standard arbitration statute does not address those, and the model rules and the model acts do. The other place where the model acts vary from our state statute is they address the qualifications of the arbitrator. They indicate that the arbitrator should be an attorney in good standing who's trained in arbitration, or it should be a retired judge who is knowledgeable about the substantive field of family law. The model acts specify that these arbitrators should have additional training in identifying the signs of domestic violence and the signs of child abuse, making it certainly a very family law specific model acts. The acts have very specific disclosure requirements. You know, the family law practice community is pretty discreet, DISCRETE. It's a, you know, we all know each other just like the other practitioners in the other fields know each other. So the requirement of disclosure prior to the engagement is of critical importance, so that all relationships, prior relationships with counsel can be disclosed, so that the parties know that they are getting a true neutral, and they don't have to worry about even the appearance of a possibility of partiality on the part of an arbitrator being considered. The authority for interim awards of support and other matters is very specifically set out in the uniform acts, not so much in our state act.
The other thing that I noticed in reading those, there was a specific to getting your scheduling order and your discovery order. And I know we have some of these that get given to us by family court judges, and it's like, this is your scheduling order, and it's not really a discussion. And so in the arbitration, I think the attorneys and the arbitrator are going to have a different relationship, and maybe they're going to create that together. They're probably a little more collegiality in getting ready and getting our scheduling done.
The AAA rules, I know you all have, they're on the AAA site, and they're commercial. That's the closest set of rules available under the AAA auspices for family law cases, but they require really substantial modification to be usable in a family case. But at page 179 of your materials, we have a set of model rules for arbitration in family law disputes that are propounded by the Academy of Matrimonial Lawyers. They're much more specific, and they are much more efficient to read, and they are specific to these family law disputes. And so I commend them to your reading and to your library of materials, that there is a set of model rules available for family law cases. And that's a very good one.
And I think somehow we need to, if we try to get this moving more the way Perry and I would like to make it more available here, we're not going to be able to depend on the legislature to get us guidance. So we're going to have to use these model acts and maybe create some kind of either a local rule or just a standard for those of us who are doing it. But that, you know, it would be nice to have the statute. It's interesting. I come from Oklahoma. And when I first heard about parenting coordination, it was somebody from Oklahoma presenting, and they said, truly, if we can have a statute for parenting coordination, every state can. Well, we still don't have one in Missouri, and they also, Oklahoma has, a Uniform Arbitration for Family Cases Act. So we aren't going to be able to rely on our legislature. I don't think they're particularly looking to do those kinds of things for us. What else can we address? I think we talked about the prenup. The prenup could say only interpretation is going to be arbitrated. The prenup could say that property and support is going to be arbitrated, marital support. You cannot put in your prenup that if any children are born of the marriage, that is going to be arbitrated. It can't be decided. That would not be informed consent, I think, is the concern there. Not to mention in Missouri, we cannot. And I want to make a point that if you're arbitrating and you can't do the custody, it still may kind of shake the trees around. These people have been in the arbitrator's courtroom or conference room. They're seeing their attorneys in action more. Maybe they'll say, hey, we don't need to go to the judge. Let's, you guys help us figure this out, to their attorneys. Or maybe they'll go to mediation. So I don't think it means we're not going to help people in the custody regard. That in the divorce, you can do your valuation of businesses, your division of assets, tax consequences. When sometimes it's when I put this in a separation agreement for a divorce, I'm thinking, okay, we have some agreements because maintenance is going to get paid out as part, somebody's bonus is going to be paid out for maintenance over a period of 5 years. And you can put in all sorts of language about who's going to do the taxes. What if somebody didn't like that calculation? What do they do? You can have pages of how to make that calculation, and then there can still be a dispute. So if you add that if there's a dispute, you're going to arbitrate it and not go to court, because hard to get a divorce in court, try to get that.
It's tricky. I mean, the circumstances change. The ground is always changing in these cases. You may have a history of employment, and then your circumstances may change to a different form. So the galaxy of issues that could be arbitrated is really, it seems almost limitless. You could arbitrate the validity and enforceability of a prenuptial agreement. And then you can, if it stands up, you can arbitrate the application of the agreement to the facts of that case. As Ann was saying, you can arbitrate calculations, you can arbitrate tax consequences. Valuation is a very significant issue in family law, where there's a family business or some unusual asset, and that holds up a lot of settlements and a lot of resolutions. If you could arbitrate the valuation, get that resolved, and have stipulated that the arbitrated decision will be what's used, you really move the case along. We're down to, it looks like about,
good question.
Oh, we do?
Yeah. Would we recommend arbitration in cases with one or both pro se parties? I thought about this last night when I was going over my notes. I thought how much judges hate pro se, and so many pro se. The concept was, hey, no property, no kids, we'll help you run your divorce through. Now people are trying to do big things in pro se cases, and I think they should be arbitrating. I think that would be fantastic.
That may be. I think one reason for the frustration of the courts with pro se parties is the courts are aware of the substantial nature of the interests being determined, and the parties may not be, but the courts can't help guide them, and they're frustrated because they know this is really how we need to handle this, but they say, I can't give you legal advice, and that is it. So I wonder if we would feel the same way as arbitrators to pro se parties.
Well, I'm thinking an arbitrator could come in, meet with the people and say, don't come back till you have these documents. Then you can make another appointment. I mean, it may not, but I think it's worth a try. Now with the one pro se, you have the same problem. I've heard so many stories where people are concerned that judges are looking like they're giving all the deference to the pro se party. And so when you're out of balance, I don't know.
But that pro se case is more likely to be an order of reference, it occurs to me, than an arbitration, because they won't have that pre-existing agreement to arbitrate. But it's an interesting question. It looks, Ann, like we're down to 4 minutes. Maybe we should get to the practical tips.
Practical tips, there we are. Okay, insert arbitration clauses into your separation agreements. I mentioned that And I realized, and we talk about a little information, I realized that the one that I've been using was not very good. I added to it for this. It probably still is only, partial, but it's something to think about. And one thing that I've used this for frequently is we often mediate with people or reach an agreement in collaborative practice that I do. I should have made my pitch for collaborative practice, where you settle out of court with a team of professionals. Bay rate, you make agreements sometimes for child support to extend beyond age 21 to give these kids who don't start kindergarten until they're 7 or 6, get them through college, through 4 years of school. Some people want to support their children even beyond to pay for a master's degree. So we put all this agreement in, and then we add an arbitration clause that if there is a dispute later, and the court wants to, the court says, wait a minute, this is a 23-year-old. Why are you back in family court? You can arbitrate.
You should have a good contract, the arbitration contract. It should be very specific as to how the expense is going to be paid. It should be very specific as to what issues are being arbitrated. It can't just say to hear them, it could, to hear the matter, but it's not very helpful and it creates a lot of ambiguity. It should also address when are we going to get the award so that the parties know what they can look forward to in terms of their expectations. It should specify where it will take place and under what auspices and who's going to arrange for the reporter for the record. It should also specify what rules are going to be used for the proceeding. And that's where I would say, look at those Academy of Matrimonial Lawyers model rules for use in that arbitration proceeding.
And we would say in conclusion, we have a conclusion paragraph.
Speak for yourself. Okay.
But in conclusion, we would say people need to consider arbitration for family law disputes. And we should, as a community, maybe work towards making it happen more. And it's certainly one of the items we can have in our toolboxes as a way to help our families move forward.
Thank
Fabulous.
you very much.
And I thank you, Karen.
I thank you.
Let me, we have just a couple of minutes and just a couple of thoughts speaking about practical tips. And Carrie, you mentioned some of the things about which should be in your contract. Do you suggest that the parties either negotiate the identity of who the arbitrator or the panel of arbitrators will be, or provide in the contract the mechanism for selection? Is it each party will nominate someone and those two nominators will select the arbitrator? Or are you looking for an organization to provide you with 5 names and you have a strike list and you can strike 2 and you rank the orders of preference? What are your thoughts in terms of arbitrator selection?
Well, I have a very strong reaction to choosing 2 arbitrators who choose the 3rd. We have that in our parenting plan in St. Louis County, 2 mediators. If you can't agree on a mediator, you get 2 mediators to agree on the 3rd. Who wants to be worried about somebody? Nobody's paying you to do that. So I think you need in your contracts how it's going to be selected, and you don't put a burden on people who are never going to be paid or see you again of selecting for you.
I think it's hard. It will be hard to convince lay people to agree in a settlement document or a prenuptial agreement to the use of arbitration in the event of a dispute, unless you've really carefully spelled out how that arbitrator would be qualified to hear it or selected. So it's a good question, Rob, and I'm inclined to think it's a drafting issue, and I think the more specific it could be, probably the better.
I would tend to agree that the agreements I see that are really in the best practice category have specific qualifications for who is sitting as the arbitrator. They are licensed in Missouri, have practiced, in your case, family law for X numbers of years. So you're not getting someone who just passed the bar in July who's going to be determining the issues in the case. The other thing I wonder is, oftentimes parties will go to someone to say, we're going to select you as the arbitrator. And if they call Ann and say, Ann, we want you to be the arbitrator on this dispute, one of the things we get concerned about is the ex parte communication with Ann as the arbitrator, and whether it's USA&M or AAA or JAMS or whoever, I would throw out as a best practice, have someone administer the case. So the arbitrator is behind that Chinese wall and is not having direct communication with the parties or the lawyers. Things like getting a deposit to cover the arbitrator cost. You don't want the arbitrator to necessarily know that the plaintiff has paid and the defendant hasn't. Let an independent party take care of that. Take care of scheduling, for example.
Well, it's a new area, and I think that's an excellent consideration. You know, Rob, also, there are states, of course, with board certification in family law, like other fields. We don't have it, of course, here, but that could be another thing that you might include if you were in such a state.
Great idea. And one thing, because of COVID, you talked about some of the cost saving, the time saving could be dramatic because yes, we're protecting parties, we're protecting lawyers, we're protecting the arbitrators. You can conduct an arbitration hearing by Zoom. It wasn't that conference room at your firm, Carrie, but another conference room where I served as an arbitrator, and it came off flawlessly, where exhibits were all identified in advance and they were shared, and the panel of arbitrators could see everything, and it was done. Sometimes there are out-of-state witnesses, especially you mentioned valuation of a business. You may have out-of-town experts. They could appear wherever they are. So it's both speed and cost efficiency, I think, might help drive more disputes going to arbitration in the family law area. So it's something that I think a lot of us are going to be thinking about, and really the beginning of a new area for resolving disputes and, frankly, helping out the bench. So great ideas, great thoughts. Both of you, thank you. We appreciate
Thank you for inviting us.
Your experience and the training that you've presented to us. Folks, we're going to take about 5 minutes, and we'll get set up with the next program. Thanks again.
Thanks you
again, Rob.
Mm-hmm. Why don't we go ahead and get started our second program in just a minute. Just a couple of general announcements. First, as Ann mentioned, and Carrie, I want to thank Kelly Spiller of our office, who coordinates these programs. We had somewhere north of 75 register. She handles the CLE applications, et cetera, and does a fabulous job. One of the things that the Missouri CLE does require of us as a provider of CLE programs that are accredited is to have evaluations on hand for their benefit. And we ask you, in the very beginning of your materials, there is an evaluation form which you can fill out, send by mail, send by email, and I believe that Kelly will also send another copy after the program that you can fill out via email. Right behind that evaluation is a certificate of CLE credit. At the bottom of that form is for Missouri credit only. We also have applied for Illinois credit, but the Missouri program ID number for our seminar today is 682902. That number is on the bottom of the best practice certificate that's in your materials. Again, Missouri Program ID 682902. Without further ado, the next 50 minutes will be covering the area of mediation advocacy, and the focus is preparing us as lawyers in representing our clients at mediation. Two great presenters. An old friend, CJ Larkin, formerly of WashU, has been teaching various ADR courses at the Sturm College of Law at University of Denver, and is participating in mediating landlord-tenant disputes here in St. Louis, and does a million other things, and is an outstanding practitioner and teacher in the area of ADR. Wesley Parks, a colleague of CJ's at the Sturm College of Law in Denver, also a seasoned ADR professional, and also mediates in the Denver area. More about their bios, the bios of all of our presenters are at the very back of the materials that we've presented to you. Without further ado, CJ, you want to lead off?
Oh, I'll just say hello a second and just a couple of comments, and then I think we sort of divided up our presentation with y'all with our PowerPoints. I know I'm looking at the list of folks who are here. I didn't want to scare Wesley, but wow, like some real power hitters. So we think, you know, there are several of you who could teach this or certainly add to this. So I know many of you are arbitrators and mediators. Maybe if you think about it, and perhaps you don't represent clients so much in these processes, but if you can think about, are any of the comments we make may be helpful to you as you might make suggestions to people in your mediations. Like, yeah, I see that a lot. I wish they wouldn't do that, or I wish they would do that. And perhaps you might give a little guidance to people when you're in the mediator role.
I'm certainly honored to be here. I do have some fond memories of living in Columbia, Missouri. I am a former Tiger. So when CJ gave me the opportunity to partake in this, I certainly latched onto it immediately. So a little bit about me and my practice. I do mediations in Colorado through a court annex mediation program that we have called the Colorado Dispute Office of Dispute Resolution. I mediate mostly family law, some civil, probate. I also mediate bankruptcy and Department of Education disputes that involve complex IDEA matters. And CJ, I'll let you talk about what areas you practice in as well.
Oh, okay, so yeah, so we do a lot of similar practice, and I think that we when we created this presentation, we wanted to be sure that we weren't only talking to family mediators, because I know a lot of people on the panel for USA&M don't necessarily do a lot of family. So, but we think that we've done a pretty good job of talking about other cases that we've handled. You know, Wesley mentioned bankruptcy, I do employment, and some commercial things. And so we're trying to sort of bridge those two worlds, but we recognize that they are kind of different.
All right, with that, we'll go ahead and get started with our program today. So the history of mediation advocacy, it's kind of interesting. You know, both CJ and I have taught and do teach actively mediation, negotiation, alternative dispute resolution. But historically, law schools have not taught mediation advocacy. I did an informal survey in 2017 with a colleague of mine, Alexis Sample, and we found that at that time, about 7% of law schools required an ADR class. Hopefully that's increased since 2017. However, I think often as practitioners, attorneys, you are faced with some newer graduates that aren't as seasoned and don't have the experience of dealing with this process of representing clients in a mediation environment. And so it's difficult. So we didn't even start teaching trial advocacy in law schools until the 1960s. And in the 1990s is when mediation advocacy started coming up as potentially something that should be taught to law students. The pedagogy is still very inconsistent at this point. Should it be more collaborative, or should we be teaching more spin to win types of advocacy and mediation? And so there still has not been a real focus. And CJ, did you want to add a little bit to that?
I would just say that just a little plug for our representation and mediation competition, the ABA competition. Wesley and I, Mike Geigerman, Jim Reeves, I'm sure Rob helps too, have all tried to coach students in this competition that focuses very much on that representing clients in a mediation takes special skills and a slightly different mindset.
So there are many, it's a dynamic process, as we all know, and there are many interactive dynamics. And of course, being an attorney myself, I tend to think that as an attorney in mediation, you play a central role. And there are a lot of different relationships that have to be managed, whether it be between you and your own client, you as the attorney and the opposing counsel and party, and you as the mediator. So preparing for these interactive dynamics between all these different competing interests during a mediation is important. And the focus of this particular presentation is how to prepare and suggestions for preparing so that you can manage these different types of dynamics in a mediation. So one thing to keep in mind, obviously, is that mediation there's different procedural norms in the mediation. And this is a list from a scholar named Amsterdam, but it's a really good list to look at and to start thinking about when you're counseling your clients as to the difference between the litigation process and the mediation process. Oftentimes our clients come to us and they have this one set view of what dispute resolution in the court should look like, and it often involves their view of what they saw on Ally McBeal or what they grew up watching, Law and Order. So the procedural norms are quite different, and talking to your clients about that is important in advance. And these are some of the norms up here: cooperation, voluntariness, participation, sharing information, talking about confidentiality, dealing with emotions, which oftentimes both clients and attorneys sometimes have difficulty dealing with, and the focus on the future instead of the past. There's also substantive norms, which we'll have CJ discuss.
Yeah, so this is sort of the assumptions that you'll come up with, right? And again, it depends on what kind of subject matter you have, but there's usually some concept that at least one of the parties has been wronged or damaged. You're at fault, you're responsible to the other side. And then there's denial and limitation, right? There's usually an exploration of claim damages. There's offer, counter offer, and law and possible litigation comes in. That's very much a strategy. You might want to coach people on when they hammer that and when they don't. We've seen students and lawyers in practice who either hit it too hard or they don't talk about it at all. And we think that can be really problematic. So it's a nice balance. And and that really equity and fairness come up. I had a mediation yesterday where one of the parties said, well, that may be what the law is, but what's fair? We've been friends for 20 years, So recognizing that those sorts of, as you mentioned earlier, Wesley, that emotions, relationships, interpersonal expectations, acknowledging things, apologies, all those things come in and have a place in mediation where they may not otherwise. And the idea is that the settlement, if possible, resolves all issues. But I think we all know that many times we'll do partial settlements, right? At least they funnel down the issues to where hopefully there's none left or they are a little more manageable.
And I think that you make a good point, CJ, in that there are legal norms and non-legal norms, and sometimes exploring both of them, legal and non-legal, can assist you with creative problem solving that might uncover or shed light on a possible solution that otherwise you might not have seen if you don't explore the non-legal aspects of the case. So goals of the advocate. Go ahead, CJ.
Yeah, just so what are the can you pull them all down? I'm sure that I have to see everything at once. Thanks though. So this should be what both lawyers or all lawyers involved should be looking at. They're trying to persuade the other side, mostly, right? I mean, honestly, a little bit, they're trying to persuade you or get you to understand their point of view. They want to show their client that they know what they're doing, they're good at what they're doing. They should want to demonstrate that they're making a good faith effort, right? Sometimes people don't, and then they say, and that is, I'm using my my mediation hat today, and I'm trying to settle in good faith. And you think, really, right? But that is, that's one of the things they should try to do. Obviously, the strengths of their party, weakness of the other. Avoiding exaggeration, I think that is a strategy question, right? But I know as a mediator that when people are super exaggerating and extreme, I pay attention, but I don't know if it's so persuasive to everyone, right? The idea of mutual compromise, they should hopefully bring that up and hopefully come with multiple options for settlement. That's the one thing WashU and DU have been great within that competition, is telling our students, come with 10 things, right? The different directions you could go. I think attorneys do their clients a disservice when they come in with really like one idea. And they don't recognize how many different directions the mediation can take.
And I think overall, demonstrating keen knowledge of the case can influence the other side, and will allow the other side also to evaluate your own skill, right? And even if you have disagreements, I would encourage you out there to consider how important the face-to-face aspects of a mediation can be. I think too often, and there's a little article at the end of your materials about the benefits of the joint session, specifically in family law matters, but I think it can apply to all mediations. But the ability to persuade can be impeded if you're shuttling back and forth. So I would encourage you to consider some of the benefits of the joint session, because in order to achieve some of these goals, sometimes the other party seeing you in action can help you do that. Persuading the mediator.
So persuading the mediator may be a controversial thing to even say, right? Oh no, I don't care what happens. But one of the, if you want to think about it as you're persuading everyone, I've got the law on my side, the cause is right, they're wrong, my client has been wronged, or the others, my client is innocent, whichever, that justice is important. I've coached my client to and talk to them about, looking at this broadly, being open to settlement, willing to discuss settlement. Now, there's some people who will disagree with that. I have colleagues who say, I will make sure the mediator knows we are not compromising on anything, because I actually had a mediator and a client attorney in an employment case say, I'm going to act like I'm not going to move at all, because if the mediator thinks I'm soft, I'll be the one they push on, right? So it is, I recognize this is not everyone's approach, but I think that it sort of, from my point of view as a mediator, I really appreciate that work that would have been done to at least consider this. And I hope I don't only push on people who are willing to settle, but I think that to some degree it is what do I want to say, sort of old thing. We're going to come in and just yell and scream and get our way. I see many more, we talk about new attorneys, but I see many new attorneys coming in right away, assuming here's our range, here's what we're going to try to do.
I think one thing that comes to my mind when I think of persuading the mediator is yes, a mediator is neutral, but that does not mean that a mediator doesn't have an opinion, right? And so I think it's a little bit more nuanced, using nuanced skills to persuade the mediator to work on your behalf, to get the settlement that you and your client are looking for. And I think there are ways to do that while the mediator still respects the mediator's ethical obligation to remain neutral throughout the process.
So if the mediator doesn't understand the weight of what your argument is and your narrative is, it's going to be hard for them to sell it. I'm channeling Mike Geigerman. So how can I sell that? Because that doesn't make any sense to me. So the idea is to sort of make the mediator in their own mindset know what it is you want, and hopefully have a good narrative rationale for why.
Yeah, good narrative rationale, good objective criteria. Oftentimes, I spend a lot of time in caucus gathering the evidence that the other party wants me to bring over to the other side to help persuade the other side. So a lot of things to think about. Good points there. Next slide. All right, so using the mediator to communicate. So there's obviously a bias, bias is being talked about a lot these days, but there's a bias when you're dealing and facing with someone who is perceived as an opponent. And oftentimes you deal with these biases, reactive valuation, for instance, where an offer causes you to want to escalate your side just because, well, if they're offering that, then we must have undervalued our case, right? So you want to reactively increase the value. And then there's reactive devaluation, where you receive a proposal from the other side that, even though in preparation phase would have been within your settlement range, suddenly it's no longer, because you devalued it based on where the message is coming from. So using the mediator to reframe and to deliver those messages in a way that deals with some of these biases is one way that the mediator can communicate for you to avoid some of these biases, to push the negotiation forward and avoid impasse and hopefully find a solution. Anything you wanted to add to that?
Oh, that's good.
Go ahead.
So when we were preparing this process, I call scripting. I don't know if I created that. Somebody else may have used the term before. I was saying, when we talk about this, Geigerman, if he's there, is going to tell me he totally disagrees. So recognize this is my strategy as a mediator, and also the coaching strategy for my students, and actually in both schools, was to, when you're in caucus, for the mediator to be very clear when she or he leaves the mediation, what do you want me to say? Am I conveying an offer or a question or a proposal, whatever? And how do you want me to say it? Here's what I'm going to say. Here's the rationale I'm going to give. Is that okay? Oh, you've told me not to mention that, so of course I'm not going to mention that. And then what I do is I ask questions like, okay, so I'm going to be over here with them. What if, and I anticipate questions. What if they ask me this? What if they ask me that? I have a feeling they don't like this part of things. Do you want to explore some other options to that? Anyway, so that I think it's really important, when I am the mouthpiece for these people, when I go into the other room, I'm very, very concerned that I convey the totality of what they want me to convey, and that I have thought ahead of time enough so that I don't have to keep coming back. Now, Zoom, it's not so hard to come back and forth. If you're running at USA&M between rooms, maybe you get your steps in. But I really want to feel like I have a pretty thorough command of anything that could come up, what I think is problematic with what they've said, frankly, right? And to be really understood. Many times people give you a tiered proposal. First, I want this, but if they won't take that, then I'll talk about paying half, and it kind of expands after that, I suppose. Now, I think Geigerman, for example, handles this totally differently. I think he says, I'm going in there, tell me something you don't want me to know. He's not here, I don't think, today to defend himself. But I think that this is just that's my way of, I often tell participants, not many ways a mediator can mess up, but saying something we're not supposed to say, making an offer we shouldn't make, whatever, that's one of them. So I'm going to make sure you feel confident. And the reason I like it as a mediator is that I think it builds trust. I think they really feel increasingly comfortable, and more comfortable sooner, that I'm only going to say what it is that they really want me to say. Now, from the point of view of an advocate, we teach our students, before that mediator leaves the room, you say, so CJ, so could you tell us kind of how you're going to present this, and what do you think? And just make sure, of course, you don't say this and you don't say that. Because I think many times people think, now go off and do it, right? And I think sometimes, particularly with new advocates, maybe they're not always 100% sure what you're going to say, and it's helpful to do this.
And just to add to that, TJ, I think clarity is helpful. While you're speaking, I was just thinking about, I was shuttling yesterday in a mediation, and it was a family law mediation, but there was a large estate, and there was a lot going on between the divorcing couple, and one of the parties had gone on a narrative in caucus, and at the beginning of the narrative had expressed that he wanted things to remain confidential. So, yeah, and so I spent a lot of time having to review and go back to like what can I and can I not share, because you went on a really long narrative there. So I think clarity and preparing a list of what the expectation of the mediator, what expectations you have for the mediator in regards to what you want to keep confidential and what you don't want to keep confidential, it would be beneficial. So having that specified list, and so at the end of that caucus, for instance, yesterday, when I asked, okay, let's review what I can and can't share, essentially they're like, well, everything. And certainly everything wasn't the answer, right? So like being prepared with what specifically is a non-share item and what would be beneficial for the mediator as well.
I would add one thing. For some reason, twice in the last month, I've had mediations where I said, here's what I'm going to say. And either the attorney or the client said, hey, don't give them the impression that whatever, that we're really overwilling to settle. Don't give them the impression that I am not as interested in this or that. So they really took what I said and, I tweaked it a little bit because they were afraid I was giving a message they didn't want me to give, or they were afraid the other side they know the other side better than I do. And they knew that if you say this, they'll take it to mean that. So they tweak it for you. And I think I think it saves a lot of problems if you let them do that for you.
So as far as, I teach about this, changing focus slightly here, looking at some research to support mediation advocacy. The more you know as an attorney about mediation, the better outcomes you can have in mediation. So one thing about our field is that because of the confidentiality protections, there are few empirical studies. More are growing. There are a couple that just came out of Maryland where they actually did an intra-mediation long-term study. But this particular study here, I think, is important for mediation advocates to be aware of. It's this Kaiser study, and then Frankel and Stark, who are scholars in our field, ended up following up the study. But this study was of 5,000 California litigators in 2,000 contested cases in the Bay Area. And so they looked at the mediation and negotiation outcomes vis-a-vis the last offer that was offered. And they defined an attorney error as rejecting an offer that was better than or equal to trial results in the end. And there was a finding that the mediation training and experience correlated to less attorney error, and they monetize that. It costs more for the defendants and plaintiffs, as you can see on the slide. But I think the importance of this is that keeping in tune with mediation as a process, making sure that you understand the process, will give you the ability to advise your client better on when or when not to settle in a case. And Frankel and Stark advanced this Kaiser study, and they came to the conclusion that likely reason for this is that attorneys that are trained in mediation have the ability to look at the dispute, turn the crystal on the dispute, and look at it from all different angles, and thereby it has a de-biasing effect that helps them grow empathy and also identify when settlement is optimal for their client. So just something to think about here.
So I'm looking at time. We kind of timed when we should be halfway through our slides, and we're not there. So why don't we just, the risks of mediation are there. There's a cartoon.
A little cartoon, what is good faith? So often one of the risks that we talk about is that parties and participants aren't going to act in good faith when they're mediating, and good faith is hard to define. So we have up here just you're acting in good faith if you're complying with statute. Everyone's there, all the stakeholders are there. You've prepared, engaged in discussions, and so you can read this on your own. What's not in good faith, I think, is more important, right? Using mediation to gain advantage, impose hardship, misrepresent, avoid statutory obligations, advance ulterior motives, or just using it solely for discovery. Right.
And I won't say that it happens every week or every month even, but several times in my practice over the last 25 years, I've had a party say, are you going to report them for failing to act in good faith. And this is like after the first offer. So it is a strategy, or it is a perception. Well, I'm not even saying a strategy. It is something that counsel on the other side looks at and often brings up if they feel that it is being done in bad faith.
All right, so the next part of our discussion, this is kind of an overview. We're going to talk about preparing a representation plan, which includes these components: so mediator selection, conferences with your client, presenting opening statements, and how to switch from joint sessions to caucus strategically. So mediator selection.
Yeah, so this is sort of, it's an interesting thing for us to talk about to a bunch of mediators, but some of it is particularly for new attorneys, but in general, to say, you know, if you have a choice, sometimes you're assigned someone, but if you have a choice, what are you looking at, right? Like, do you have someone, does your firm or whoever the entity, does the EEOC, whoever the entity is you're in front of, or do they have a preferred person? Have you had somebody before? Do they need subject matter expertise? Is it securities reg? Don't call me, right? Because I will I'll break out in a rash. I don't want to do that. Have they had the training that you want? And the process expertise is actually an interesting one. The whole thing about Zoom, there are just some mediators who are better on Zoom, who feel more comfortable, some mediators who are better with document creation or DocuSign, Adobe Acrobat, all that thing. And so is that something you need the mediator to do or not? If it's a multi-party, huge, lots of documents, can they handle that many people, that much documentation? Maybe they need support staff to do it, but those sorts of questions. Personality traits. Is this person, you know, a great person basically, but they are a little heavy-handed sometimes, a little evaluative, and you've got a client who's allergic to that. So what is their personality trait or their, you know, or their style of mediation? Conflict of interest, obviously, there you go. Do they have the time and focus? I had a mediator in a case once was about to deliver triplets. And it was like, I don't know, really, if you're going to be after this, right? Or you know, maybe somebody's going into rehab, whatever it is just recognize what's going on in their life. Are they involved in some huge other endeavor? And again, we said style and what is your preference? And of course, you've got the other side who's got to agree if you guys are really getting a choice.
So preparation, preparing your client does correlate with increased client satisfaction. This Whistler study from 2010, it was a continuation of a Harvard Law Review study by Andrea Kumpfer-Schneider, who found that attorneys who are more use a more problem-solving approach are perceived by clients and others as being more efficient negotiators. So this Whistler study actually looked at preparation and found that it increases the more there's a correlation between client preparing for mediation and clients' perceived fairness of the process, perceived mediator impartiality, lack of coercion, increases in parties' perceived involvement in self-determination, which is also correlated with outcome substantive fairness perception, and it increases the lawyer's ability to evaluate the case from both sides. So preparing can thereby decrease incidences, and I'm doing some research on this with another colleague right now about self-determination and settlement fortitude, and whether there's a correlation there. And some of the studies are finding that there is. So potentially preparation and then coming to an outcome will result in less post-mediation litigation. So there are a lot of benefits. Some are being studied actively right now to get the data, but we know from this study here that there are perceptions of fairness and impartiality, and also as it relates to the Schneider study, perceptions of your ability to negotiate in mediation.
And if I could jump in, there was an ABA study done about, 10, 12 years ago now that was talking about satisfaction with mediation sort of across the practice. They only interviewed attorneys, but whatever. And one thing that people all agreed on was that they hated and thought it was counterproductive if the other side, obviously always the other side, wasn't prepared. That the lack of preparation, sometimes of the mediator, but also of parties, led to a waste of time, lack of settlement. And I think you all could write very interesting things in the chat about your experience. I think this I think as mediators, we can encourage some additional level of, or an increased or sufficient level of preparation. It depends, right? I mean, I don't think we can fault someone or criticize someone if not, but I think I've done mediations where I was starting with people from scratch. Their lawyers hadn't done anything with them. Really, we're all learning together. And like, you want to pay me for that time? That's great. But I think that we as mediators can ask for, you know, I think most of you do, mediators briefs, memos, documents, and encourage people to do that. Now, they may not want to pay us to read them for the time it may take, but at the very least, I think it really, we can encourage them to focus. And I think particularly with new attorneys, you are setting their standards. Like, this is what's expected when you go to mediation, and hopefully their practice will be elevated because of that.
Yeah, the last paragraph of my agreement to mediate, I do talk about a pre-mediation statement or brief, and I give them an outline of what I expect in that. And I always say it's optional, of course. And maybe that's why I don't get I don't get 100% response to it. But and I also say, please give it to me a week in advance, and I usually get it like a couple hours before or a day before. But that's something to think about as well, is to include it in your agreement to mediate. So things to, this is a client preparation slide here, and I think that's me. So you know, I always, when I'm representing clients, I start talking about ADR, different ways to resolve a dispute at the initial consult phase, you know, and so it gives you as an attorney the opportunity to give a pulse, get the pulse on the client, whether they're settlement driven and whether or not your incentives also align in representation. So starting to educate your client about the mediation process before the mediation, as early as your initial contact with the client, I think would only benefit you and as an advocate when mediation actually occurs. You know, those questions that CJ put forth about learning about the mediator, using those questions, I find that when I'm representing clients, I often go back to that list of questions, CJ, that you put up there, and I find them very helpful. Providing a litigation risk assessment, you know, not a lot of clients know that, you know, in the federal district courts, for instance, less than 0.5% of civil cases went to trial last year. The year before, it was less than 1%. I think it was 0.7% in the United States district courts actually were resolved in trial. So most cases do resolve before, you know, an ADR process or dispositive motions. But either way, trial is not usually the way a dispute in the court system is resolved. This one's yours.
So yeah, and I think I'm not usually agenda person, but I'm keeping track of time a little bit. I think you guys can see the just sort of the points we're making here, and I think it is. Sometimes I think as mediators, we're in caucus for someone and we realize these things have not happened yet. So sometimes it's on us. Well, you know, this is what's going to happen next, and this is how we're going to go, and basically say, like, you know, well, what's kept you all from settling? It would be great if this was done ahead of time, but again, this may just be a list. It's probably something we all do is when we realize, hey, these people haven't gone very far in it.
Right. I think one thing that's I find it beneficial and important is to develop that central theme with your client that deals with the core issue with a focus on what the underlying interest of your client is. That's the why behind the position. I think too often we're too position focused and we don't look at the why. And if we could really find out that underlying interest, maybe find a common underlying interest with the other party, that can open up doors to problem solving that you may not have seen before. And it can really increase positive outcomes in the mediation.
So Leslie, I think we've got about 10 minutes if we want to leave 5 minutes for questions, which they've already been some. So, you know, go ahead and go through.
Sure. Yeah. Let's just talk about the pre-mediation memo or brief initial consideration. You know, what law applies. Obviously, there are certain courts that do have specifics for the brief, and what does the mediator want to review. For instance, if you have, you know, in bankruptcy, oftentimes there's a retired bankruptcy judge that is conducting the mediation, and so, you know, in my thoughts, and a bankruptcy judge typically wants a more formal brief type pre-mediation statement. And so how should the document be formatted? Should it be a letter? Should it be more brief? Who's going to receive it? You know, is it confidential between you and the mediator only, or is your client going to see it? Are you going to let the mediator know some of the challenges that you're having with your client? Perhaps maybe you shouldn't have your client see it, or maybe you should call the mediator to talk about some of those challenges that you're having with your client and get your client so that your client doesn't see it in writing. But these are things to think about, deadlines for submission as well. So content, you know, this is just a basic outline of things that you might want to consider including in a good pre-mediation statement. Summary of facts, description of the stakeholders. I think that makes you think about, make sure that everyone's there that needs to be there, or you've identified everyone. Are there shadow stakeholders, people who might have an influence on the mediation outcome who aren't there? What's the procedural history, core legal matters? You know, typically when I'm meeting, I don't expect a more formal brief, but I do like to know the core legal matters that are involved so that at least I can brush up on them beforehand, but not necessary for you to give me a brief type of document. History of settlement expiration, whether there are any impediments to settlement, and sometimes those can be, you know, from personality issues to, you know, there's a lot of different types of impediments that you can think of. Whether or not an apology needs to be given, because, you know, putting that in a mediation statement, putting the mediator on notice that that might be something that will help drive the negotiation forward to settlement. Mediator can then plan for those added protections, perhaps coaching, caucusing to make sure that it's done in a manner that does protect confidences. Understanding strengths and weaknesses from both sides are important, and also identifying those underlying interests.
So, I'm sorry, process suggestions to mediator, which people like, you know, why don't you start with this, or don't talk about that, or, you know, this is a chronological issue, we have an immediate issue, let's deal with that. One of the things I would say about this, you know, we are as mediators able to impact this. If we say, here's what we want for your statement to us or information to us to contain. And if you put in there that you know, is there a need for acknowledgement or apology? I think that they realize, oh yeah, I think my client would be a lot nicer if, or a lot more amenable if, or, you know, if the other side apologized, or maybe we should. It raises, you know, the thing, sort of the raises the point, this is not the same as being in court, right? You're not going to apologize in court probably. So, and looking at process suggestions, which are, lots of times people thought, well, I haven't thought about this. I thought you would just go. Well, maybe we really want you to look at this set of invoices first. You know, give me some guidance as a mediator. And if you ask for it, many times they'll give it to you.
One other thing I'd like to add here, if you're going to include a settlement proposal, I think it's also important to include an agenda, and don't underestimate the importance of the agenda, because it gives you an opportunity as an advocate to define the issues, and perhaps to define the issues in a manner that are beneficial to your client. Right. And so a good example I use in my classes are, you know, if you're dealing with a family law dispute and someone is in contempt, you know, are you going to, of a parenting plan, is the agenda item 1 going to be contempt, the contempt issue, or can we reframe that or change that that agenda item to amending the parenting plan so that both parties can avoid contempt, right? So there's different ways to define items in an agenda that are problem solving and potentially beneficial to your client that you can put in a pre-mediation statement that will get the mediator thinking about problem solving for you and how to facilitate that.
So Wesley, in the interest of time, what I think is, let me just introduce these common errors. Why don't you pick one you want and I'll pick one I want, and then they can read it. And I know we've had at least 2 comments about Zoom stuff, so maybe we'll say a smidge about that and go to some questions. So I think the one that I want to talk about most, and I'm sorry if it goes beyond the one you want to do, I want to go to slide 31. I want to talk about humiliating, et cetera, et cetera, et cetera. There we go. Yeah, push them all down. So I often tell, well, I tell my students for sure, but I think it's also really true. I have seen some incredible statements being made by counsel during mediation, particularly in employment cases sometimes. But I just had one in a divorce mediation where I think the attorney hated the other party so much that I'm not even getting paid for this, but I'm after this person anyway. So I really think that, and I think this is an interesting question for the mediator. So I have had to stop statements being made by counsel because I could just see the other side closing up, particularly if we're in joint session, right? And I have seen people, it just get out of hand. And I think it totally undermines, perhaps there was a willingness to collaborate, then they come in and they get that, and people will say, oh, I'm just stating the facts. Well, totally incompetent, horrible person, terrible mother, terrible employee. I don't know if that's stating facts. So I really think that that is something that is an interesting issue, right? Do you want to stop a lawyer from saying, here's sort of where we are, a lawyer or client, right? But I do believe that it is maybe an interaction between the mediator and the client or the attorney to say, hey, I'm afraid they're not listening to you anymore, right? I think they're really, let's go back. Concomitantly and flip it, I have a couple of really my favorite St. Louis lawyers who are great advocates, but they manage actually to be trusted and liked by the other side. I have seen a couple lawyers in particular turn a client who was angry at the other client, but liked the lawyer and trusted him. Because sometimes people won't settle if they say, I hate that SOB on the other side that's representing my ex-wife or my ex-employee or whatever else. So I think this is something, a big mistake that people make. And these are Tom Arnold's 20 common mistakes. This is one of my least favorite mistakes. So you want to pick one?
Yeah, sure. The one I want to pick is closing too fast. And I think you could probably chime in on this one, but one thing that I don't like seeing are people who have settled going back to the court system to litigate over a memorandum of understanding or a settlement agreement. So I think making sure that it is a settlement that the parties are comfortable with and that they're able to execute is something that I think is very important. And closing too fast often does result in this post-mediation litigation problem that we do face. And I think as a mediator, part of our job is to assist the courts in reducing docket congestion and creating mediation litigation is contrary to that. So part of making sure that that you do take the time when necessary to make sure that the settlement is what your client wants, and that there isn't going to be a buyer's remorse after that's going to result in the end in the agreement falling apart.
And I know we're talking about mediation advocacy implying an attorney, right? I think this is a really big issue when even if you just have one pro se client, I think they tend to not really, they get anxious or they get the main thing they want and they move on. So I think this is particularly an issue for mediators, is to make sure everybody really understands all the issues. And I think sometimes I've had attorneys who had a 12 o'clock, and we started mediating at 10. And so they just want to get done. And you kind of think, I think you need another hour probably talking about this. Do you want to go ahead, Wesley?
Yeah, I think, don't forget the potential for a second session. If you feel like there's an agreement or just a pause and then reconvene to actually execute the agreement after, there's some ways to avoid this as well. But yeah, I struggle too with some of the pro bono, because there's that delicate balance as a mediator. You can't give legal advice, but you want to make sure that they are making at least that they're exercising self-determination to a certain degree without going into the legal advice. It's a very delicate balance there, and taking the time. Maybe allowing that pro se party to get some legal advice, suggesting a self-help clinic or I have a list of those that I refer to participants who are pro se if they're questioning whether or not they should sign an agreement, and then maybe schedule a second session or just a session to review and execute the agreement.
So why don't we go to the Zoom stuff and talk about it quickly, because there was at least one or two questions about that, and there was a question about joint sessions that we can have Rob tell us about. But Go
Yeah,
ahead.
so Zoom, I feel like every day there's an issue with Zoom, but make sure that others can hear you and that you know the video is on. And there's also in advance, I always open up multiple rooms. So with a breakout room on Zoom before the parties arrive, I will open up an extra room for myself so that I can go into a breakout room if I need to be, or you never know if you need to orchestrate a meeting between counsel, and you can kick them into that room and then jump in there. So having at least one additional room beyond the regular caucus rooms is always good. And my typical practice is to keep people in the waiting room until everyone arrives, so that everyone arrives at the same time. I feel like at the beginning of the mediation, potentially, if you're chatting with someone and then someone else arrives, there's a potential that your impartiality can be impeded. So my preference is to wait, but you have to notify participants in advance that that's your practice. When you log in, you're going to be in a waiting room, and I'm not going to let you in until everyone arrives. Make sure that you're clear and communicate that with the parties. Otherwise, you'll get this, they log in, they wait, they exit, they log in again, until they know that that's they have to know that that's your process, right? So make sure that you're communicating that to them. Cell phone numbers are important, having that kind of exchange with the mediator so that they can text you to come back. I always use the ask for help button. Zoom has this ask for help button at the bottom. And so when I'm caucusing back and forth, I let the parties know, if you need me for any reason to come back and to hop back into this room, just press that ask for help and it will message me to come to you. Anything you wanted to add?
No, that's good. So this is just, we won't go into this in great depth, but this is a clause that we add to our mediations that just talk about, here's what's expected, that you're going to be able to be seen and heard, and nobody else is going to be around, et cetera, et cetera. Sometimes I have to go over it, but feel free to use that if you don't already have it in yours. Let's talk about sort of the next slide is sort of ethical stuff. So it's an interesting question. One of the problems of Zoom is there could be somebody, standing over there you can't see, under the table, whatever else. So sometimes, I've had this happen where someone wanted to be in, the other side said no. Is it my job to make sure they're not there? Is it the lawyer's job to police it, to make sure it's not there? So it is really, I've done it where we've been in joint, then we went and separated the person who wasn't supposed to be there. I see their shadow walking out, right? It's still like, what do you do as the mediator? How far do you go? And I think it's, we are supposed to be monitoring the process, as we can't make it perfect. But if there's a counsel though, I have been very, I've been very, I don't know, stern. I've been very clear with them. There's a problem. I actually had a lawyer 2 weeks ago telling me, CJ, it's not that big a deal. Really? No, actually, it's a big deal to me, right? And I'd say, look, that's my ethical obligation. And people back off, but if they think it's not a big deal, they want it to not be a big deal. So
yeah, at the beginning of my sessions, I always have the parties agree verbally, and also it's also in my agreement to mediate, but I have them agree verbally to stop the session if anyone walks into their space, can see or hear what we're talking about. That I get them to agree that they will stop the mediation. I've had similar issues like CJ, where in an all-day mediation, someone who has agreed to those provisions, as the light shifted in his dining room, I could see the reflection of another party, making gestures, through the painting, there's behind that was covered in glass. So there's only so much we can do as mediators, but in that particular instance, I stopped the mediation, found out who that person was, went to the other party. It happened to be an ex-wife, talked to the other party, told the other party, who was there. She happened to be okay with it. She's like, he's going to tell her everything anyway. So I'm okay with it. Got her to sign the agreement to mediate, and then we were good, right? So that's, there are ways to problem solve that when it does happen. Right.
Well, so the appearance of Rob Litz, the good witch, who has come in his bubble, and there he is. Rob, do we have time to answer any of the questions, or are we? Because we think we started late. Maybe.
We did. So why don't you take a couple of minutes just to touch on some of the things that were in chat. One thing I will mention, speaking of Zoom, and video mediation. If folks are not aware, the federal court in St. Louis, so the Eastern District of Missouri, local rules on ADR were amended effective September 1. And so video mediations are permitted. However, the rule states that the video must be on the entire time and the audio must be on the entire time. And I'm going to guess that the federal judges did not envision folks taking their cell phones and putting it on their coffee tables so the mediator is seeing the fan spin around. Okay, they want to be able to see all of the participants, and I think it's a great rule to assist us so we're not seeing a blank screen. I just want to point that out.
Sure. So do you want to give us the two questions that were about Zoom, and then there was one about joint session, I think is all there was, but.
So why don't you touch on the joint session, because that certainly touches on every case.
Sure.
Go right ahead.
Okay, so
The question is, there's a mention of joint sessions. There seems to be an aversion to using joint sessions in civil cases. I would agree. Can you talk about why joint sessions are helpful? Do you want to tackle that?
No, you go ahead. I mean, you got.
If you go to your materials, I did give you a checklist that could be beneficial for you as you're prepping clients. It starts on page 27. And I think it applies to civil cases as well as family law cases, right? So, the list is pretty, it's not exhaustive, but there's some good pointers here. One is, different outcomes can come out when there's face-to-face sessions than when you're shuttling back and forth, and you can limit the discovery of outcomes if you are only doing a shuttle mediation. I like this one as an advocate. It gives you the opportunity to look at the other side, right? And to see potentially how the other side is going to act as a witness if you end up going to trial. And also it establishes your ability to problem solve better, right? So there's been study in the neuropsychological research of this circuit, right? So there's a face, brain, heart circuit that we've evolved through our primate ancestry of developing empathy when we can see faces, and then dealing with emotion before we can, in our brains, before we can turn into these empathetic creatures that can problem solve. So there are benefits to seeing one another when it comes to trying to problem solve. Seeing how the negotiation is unfolding firsthand is another one. Not relying on the mediator. Oftentimes I get that question. Are you? What are you saying exactly? Are you sure you're communicating? There's sometimes questions as to whether or not I'm delivering the message the way that the parties want me to deliver the message, and so you can confirm that in a joint session to make sure that the mediator is actually delivering the same message that you want them to deliver, right? Clients also can benefit from telling their stories and feel so there's a sense of procedural justice. They're not going to court and sitting on a witness stand, but they're actually being able to tell their story, and the other side is hearing their story. Sometimes there's a benefit there. Did you want to add anything?
Yeah, I just want to add two things, and one's going to be fighting words, I think, to some people. One is, as Ann and Carrie were talking about it, in their session on arbitration, it's much more efficient. I tell people when they try to decide what they want to do, I'll say, the benefit is it's a lot more efficient. But what it does do, I think joint session requires a real skill on the part of the mediator. I used to train people and say that caucus was the refuge of cowards. All right, now I'm making people mad, but it's like, yeah, it's getting hot in the room, right? But there's a lot of good that can be done. I know Jim real well, and I know that it's sort of a geographic thing, and it's also a subject matter thing. In some places and in some subject matter, people just assume you're going to say, how you doing? And maybe do your opening and be in caucus the rest of the time. And it's hard to change that norm. But they're like, what the information you've given, Wesley, is show some positive research on it.
Yeah, the present research does, I think, does support that it's probably a better practice to at least try it out. I think you can put some limitations on it, especially, okay, we're only going to give opening statements uninterrupted. No one's going to interrupt someone else, and then we'll break out. Or you can limit it to, let's just talk about the agenda. What are we going to negotiate and in what order? Right. And so that also gives you an opportunity to better define the agenda. And I think some face-to-face time is underrated, but it can have a huge positive influence on the outcome of the mediation. And you should consider it.
Rob, do you want us to stop there? Or
I think this is probably a great spot, but I should let everyone know that Wesley and CJ have agreed to take questions by email. And I can't recall if we've provided your email addresses. If not, you can send them to Kelly Spiller of our office. You have her email, and she'll pass them on to CJ and Wesley. Both of you were fabulous. We now know why we are seeing better training in our law students and our young lawyers. We are so proud of what you're doing in Denver, the folks in St. Louis, the University of Missouri. When you have the opportunity to see these new lawyers, it really makes a difference knowing, oh, when you're mediating, oh, it's a young lawyer. Well, wait a minute. This might be a young lawyer who just won their regional competition and really understands a number of the things in advocacy. So kudos to you for doing that. Also to everyone, if you're given the opportunity to volunteer to judge one of these competitions, I've done it for years. It's a great experience. It might take you a couple hours on a Saturday morning, and really a wonderful thing. Wesley, CJ, thank you both very much. We're going to go ahead and take about 3 minutes. We'll swap the share screen, and again, thank you all for your presentation. So folks, why don't we go ahead and get started with our last segment. This portion is our ethics program, and we are really fortunate to have Mark Lapp joining us. Mark is a special representative for the Office of Chief Disciplinary Counsel, State of Missouri. He's assigned to the Regional Disciplinary Committee in St. Louis City and County and counties around us here in the metro area. And Mark's day job is part of the trial team at Nationwide Insurance, a very experienced insurance defense lawyer. Mark, we're thrilled to have you. And one of the things I haven't mentioned up to now, and I would really suggest to everyone to take a look at the materials. All three programs have outstanding materials, things that you can refer to in the future. All of those were emailed to you. The links to those were emailed to you. I also want to ask, we have one of the attendees who is identified as iPhone, and if you would either in the chat or through email, let Kelly know your identity, we can make sure you get your CLE credit. Mark, without further ado, thanks so much.
Thanks, Rob. It's a pleasure to be here to speak with USA&M and all of your invitees to this wonderful conference. What I'm not going to talk about is bad faith mediation tactics or conflicts of interest of mediators. In fact, over the past 18 years that I've done work with the OCDC, I don't recall a complaint against a mediator. Not that it's not happened, but it's not something that has come to mind, and I think that's a good thing. So I invite you all to sit back and listen to a diverse amount of material I have concerning the world of ethics that I'm going to be covering in the next 50 to 55 minutes or so. I've got things broken down into 4 general topics. They're related because they're pertaining to ethics, but hopefully to give you a good sense of the concerns and the issues involved in the ethics system in the state of Missouri. The first item that I'm going to cover has to do with lawyer ethics and medical cannabis. As you all know, there was an amendment to the state constitution recently concerning medical cannabis, and lawyers are involved with clients in that area. And we're going to talk about whether there are any ethical issues regarding practice in the medical cannabis area. The second item I'm going to cover is a case from 2019. It's called In Re Scott Gardner. The case, in my mind, is significant. It not only focuses on mitigating factors that a court considers once a violation of the rules of professional conduct has been found by the court, but it also highlights a delicate balance between and among the various judges on the Supreme Court. And now, in light of the retirement of Judge Stiff and the upcoming age out retirements of a couple of the other judges, I think it's interesting to think about how that might affect lawyer ethics. And then you can also ponder how that might affect your areas of practice when it comes to the Supreme Court and ruling on its decisions. Now, the third item is I'm going to cover the statistics, the most current statistics regarding the disciplinary system. We'll go over the types of conduct that invite the most complaints and the areas of practice for lawyers that invite the most complaints. And then we are going to talk about, I'm going to call it, what have I learned? These are comments from our regional disciplinary committees. So those are the committees that sit and review the attorney ethics complaints and make a determination of probable cause. They have provided some insight into what they see is the reason for the most typical types of complaints. So hearing from them, I think, will be interesting for you all. So let's get started with lawyer ethics, the Missouri Medical Cannabis Amendment to the Constitution. As you may recall, there was a ballot initiative. It's Article 19 that was approved by the voters to the Missouri Constitution, effective December of 2018, that has made an entire system regarding medical cannabis legal in the state of Missouri. A whole industry has blossomed, for the lack of a better word. And obviously there are lawyers involved in all areas of medical cannabis, whether it's setting up contracts, assisting with businesses, giving advice, anything that you can think about with respect to business, I'd imagine can come up in this area. And there is an ethical concern that I do want to talk about. Interestingly, the drafters of the amendment to the Missouri Constitution thought about that there might be ethical prohibitions in this area, and they drafted, and this was passed, I call it an attorney ethics carve-out in the Missouri Constitution, and I want to read it for you. You can follow along on the screen. It says, an attorney shall not be subject to disciplinary action by the State Bar Association or other professional licensing body for owning, operating, investing in, being employed by, contracting with, or providing legal assistance to prospective or licensed medical marijuana facilities, qualifying patients, primary caregivers, physicians, healthcare providers, or others related to activity that is no longer subject to criminal penalties under state law pursuant to this section. So, wow, whoever drafted this section of the constitutional ballot initiative has given good thought to lawyer involvement and was concerned enough to attempt to create a carve-out. Let's take a look at what this says, though. It talks about a state bar association or other professional licensing body. In Missouri, the State Bar Association, the Missouri State Bar Association, has nothing to do with being involved in licensing with respect to lawyers. That's done through a separate agency that reports to the Supreme Court of Missouri. Is the Supreme Court of Missouri a professional licensing body? That's a good question. Maybe. If the drafter meant for this carve out to talk about disciplinary action by a court, I would wonder why it didn't say the court. So there's a question right up front of whether this generic, I'll call it, ethics carve out applies in the state of Missouri, considering that the State Bar Association doesn't deal with licensing, and professional licensing body may be ambiguous. But I'll also go the other way and say that, okay, let's assume that this carve out applies in the state of Missouri and grants by amendment to the Constitution immunity for any lawyer who is involved not only in owning or operating a medical cannabis business, but in advising clients with respect to their medical cannabis business. Well, this amendment runs up against a rule that is part of the Missouri Rules of Professional Conduct. It's Rule 4-1.2. And as lawyers, we should all be familiar with this rule that states that a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. And marijuana, at least currently, is illegal at the federal level. So right there, just by reading the actual quote of the rule, raises a question. If that carve out is there, what about Rule 4-1.2? Does the carve out grant immunity for a 4-1.2 violation? Or does the court have supremacy in this area? Well, interestingly, shortly after the amendment to the Constitution, the court, apparently on its own initiative, came out with a new comment. I only have new comment 9, but I'm going to read new comment 8 to you, and you can look that up. New comment 9 follows new comment 8. New comment 8 says, in counseling or assisting, if a state law conflicts with federal law, the lawyer should advise the clients of the fact, but cannot undertake conduct that would violate federal law, or counsel or assist the client as to how to perform an act that would violate federal law, even if that conduct would be lawful under the state statutory or constitutional law. Again, I'm reading new comment 8. It's unfortunately, I didn't include that in the slide deck, but it seems that the court was aware of this ethical carve out in the amendment to the Constitution, and perhaps wanted to make clear that they still see Rule 1.2 as being an impediment against lawyers practicing giving advice to clients in the area of medical cannabis. And comment 9 is a new comment follows. It says a lawyer may not continue assisting a client in conduct that the lawyer supposes is legally proper, but then discovers is criminal or fraudulent. And a lawyer should withdraw from the representation if they're being asked to advise or counsel regarding this matter. So, we've got a constitutional amendment, we've got this whole industry, yet we've got what appears to be a skeptical court. What is a lawyer to do? Well, if you have a question about what it is that a lawyer should do or can do, there's a resource for that. Her name is Melinda Bentley. She is the legal ethics counsel in Jefferson City, and she is the one that drafts informal opinions whenever a lawyer has a question about whether they might be violating the rules of professional conduct. And lo and behold, in February of this year, a lawyer asked a question. May a lawyer represent individuals or businesses to conduct pursuant to Article 14 of the Missouri Constitution entitled Medical Cannabis, which is also frequently referred to as medical marijuana. And her answer was a parroting of the Rule 1.2 in the comments that I read to you, which talks about the fact that practicing in that area would be in conflict with federal law. However, it says, the very last sentence, whether such conduct would violate federal law is a question outside the rules of professional conduct. There is an argument to be made that because the federal government, particularly the attorneys general over the past two presidential administrations, have come out specifically stating that they will not prosecute under federal law any medical cannabis legal activities, any activities where there is a state constitutional amendment or a state statute regarding engaging in that kind of practice, engaging in that kind of business activity. And that could be an argument that because the federal law isn't being enforced, that it shouldn't be considered something that could get a lawyer into trouble. I can't give you the answer to that. You're engaging in giving advice to a client concerning the medical marijuana business in Missouri, or you yourself are engaged in that kind of a business enterprise. That may be an ethics violation. How are we going to know? Someone's going to have to make a complaint against you, is how we're going to know. The Chief Disciplinary Counsel certainly has the authority to raise the issue before the court, but I haven't seen him show an interest in doing that. What normally happens is a client would make a complaint, just like in any other area of the law where a client isn't receiving the appropriate services in their opinion. Perhaps a client is upset with a lawyer that the lawyer has given bad advice, or the lawyer isn't being diligent, or the lawyer isn't communicating reasonably. Any of the other types of behaviors that the lawyer should be engaging in order to comply with the rules. Perhaps a client down the road is going to complain and going to raise that issue. If one of the regional disciplinary committees finds probable cause, then there will be a determination, a recommendation, perhaps a hearing on the matter. And a hearing panel may say, we don't want to follow the rule, or the rule doesn't apply, or that perhaps federal law is not being violated, and we're going to dismiss the case. Or perhaps they say that the rule is being violated and that constitutional amendment is not an effective carve out, and either a letter of admonition is issued to the lawyer, or perhaps formal charges are brought, and a hearing panel will then get to consider whether there is a violation and what, if any, recommendation it wants to make. And then finally, it'll end up before the court, and the court will then be in a position to decide this matter. Or in the interim, federal law can change explicitly, right? Perhaps there will be a congressional act that makes marijuana not a Schedule I drug, and then this entire controversy goes away. But I wanted to bring it to your attention because A, there was a carve out, and B, there was a reaction by the court with the new comments to Rule 1.2. And I'm sure that the lawyers, particularly the lawyer that asked the question to our Missouri Legal Ethics Council, is concerned that there's going to be a ramification down the road to engage in giving advice or being involved in that practice. I'm going to move on to the second topic that I wanted to cover. There was an interesting case called In re Gardner. This is In re Scott Gardner, a probate lawyer. This case was published in 2019 Not many ethics cases get published. Ethics matters which are heard by the court are ordinarily determined by the court and dealt with what we call a memorandum order, which either dismisses the case or finds a violation and just mentions that there is a violation and that there is a rule that was violated and makes the finding of what the sanction would be, whether that would be a reprimand, whether it would be a suspension or probation. If it's a suspension, whether that suspension will be stayed pending a period of probation, or whether it will be actual suspension served, or disbarment. Those are the various sanctions that the court can rule on. And what was interesting about this case is that this was a 4-3 split, and it really highlights kind of the major arguments that the court wrestles with anytime a case comes before them involving lawyer ethics. So what's this case about? Mr. Gardner was appointed as personal representative of an estate. In February 2015, Mr. Gardner requested a partial fee, his attorney's fee, before the estate was closed. The probation court issued an order allowing Mr. Gardner a partial fee, approximately half, but denying the remainder as an incentive for Mr. Gardner to finish up the estate and close it, get all of the matters resolved. Well, prior to the closure of the estate and without court permission, Mr. Gardner paid himself the remainder of his fee, $15,466. There was a complaint filed against that lawyer, which was investigated by a disciplinary hearing committee, whether the lawyer violated various aspects, various rules of the rules of professional conduct, and what should happen to him by virtue of his conduct. This was a 4-3 opinion. All the judges found that there were 4 rules that were violated by Mr. Gardner. Mr. Gardner violated the rule on taking his legal fees improperly. That's part of Rule 1.15. Candor to the court is Rule 3.3. Violating a court order is Rule 3.4. And then general misconduct of an attorney, Rule 8.4C. All of the judges found that those 4 rules were violated. The argument among the judges was what should the appropriate remedy, the appropriate sanction should be. And the court looked at the intent behind Mr. Gardner's actions. 4 of these judges found that his conduct was in part negligent and in part knowing. He, according to the majority, knew what he was doing, right? He knew he was taking his fee, knew he was taking it prior to the final order closing the probate proceeding. Yet they also found that, and they didn't go into it specifically, but I imagine that since he was getting close to the end and he knew he was going to get the remainder of his fee by statute, that taking it early was partially negligent, at least in the opinion of 4 of the judges. And as a result of this being partially negligent, the majority justified a downward departure from the standard suspension that would ordinarily have been granted, would ordinarily have been ordered, in a case like this, violating a court order, taking money at a time that he wasn't entitled to. But the majority justified a downward departure from an actual suspension and stayed the suspension and placed Mr. Gardner on probation. And the reason was the court found what they called substantial mitigating factors, including a lack of a selfish motive, no actual harm to a client and evidence of good character. And they looked at that as a reason, again, to stay the suspension and let him continue to practice law and not actually what we say is serve time for an actual suspension for the conduct. The dissent was infuriated. If you want a good read the dissent in Ray Gardner. The dissent would have suspended Mr. Gardner's license with no leave to reapply for 6 months. According to the court dissent, Mr. Gardner knew he was violating the probate's court order when he paid himself the remainder of his fee before the estate closed. And anything less than an actual indefinite suspension suggests this court tolerates lawyers knowingly violating court orders and will undoubtedly damage the public's perception of the legal profession. So again, a 4-3 decision. I'm going to go over some broader implications of that, but I want to point out that, again, the argument here about what the discipline was going to be turned on the intent of Mr. Gardner, the intent of the attorney. And the court in the majority stated, generally the baseline discipline for intentional misconduct is disbarment, for knowing misconduct is suspension, and for isolated instances of negligent misconduct is a reprimand. And in the Gardner case, as I said, the court found partial negligence, partial knowing, and again, although they did issue an order of suspension, they stayed that order of suspension and placed Mr. Gardner on a term of probation. Mitigating factors do not constitute a defense to a finding of misconduct according to the majority, but they may justify a downward departure from the presumptively proper discipline. And again, here, the court found a lack of selfish motive, no harm to the client, and evidence of good character. And Mr. Gardner had earned his fee. He had completed, or would have completed shortly after taking his final part of his fee, would have earned and did earn his fee. So here's the broader takeaway, and what I found particularly interesting is which of the judges were on the majority and which were in the dissent. And this case, this opinion was written by Judge Stith, who retired, as you may recall, from the court. Her majority opinion was joined by Judge Draper, Judge Russell, and Judge Breckenridge. And the fiery dissent was written by Judge Fisher and joined by Judge Wilson. Excuse me, it was written by Judge Powell and joined by Judge Fisher and Judge Wilson. Since that time, Judge Stith has retired, and Judge Ransom has been named to this court. So there's consideration of where Judge Ransom would fit if you were going to predict a future dispute with the court concerning a matter like this. Not only do we need to consider what Judge Ransom may think about these matters, but Judge Draper and Judge Breckenridge are nearing their age out on the Supreme Court. I think it's sometime in 2022 or sometime in 2023, Judge Draper and Judge Breckenridge, I think at different times, but in that time frame, are not going to be part of the court. And the governor will name 2 new judges in addition to Judge Ransom. And it's hard to predict what's going to happen, but I would venture to guess that perhaps the opinion of the dissent may become the opinion of the majority in a future court. But I'm not in the prediction business, but it's certainly something to think about. And I'm only looking at it in the ethics world. You can take and extrapolate what a court may do in the future in your areas of practice as you read Supreme Court opinions and wonder, try to predict without Judge Stith, but with Judge Ransom, without Judge Draper and Judge Breckenridge, but with 2 new judges on the Supreme Court. what court or how the court may feel about certain matters, whether it's in the domestic practice or the criminal justice system or any areas. I am right on time. 30 minutes is gone. Got about 25 minutes left. I want to turn to my third topic, which is an update to you all with regard to the statistics in the disciplinary system. All of this information is not only available in my materials, but it is available on the Chief Disciplinary Council's website. It's called mochiefcouncil.org. And there is a public page where the annual reports are listed, and the following information is from the most recent report, which was from 2019. Although I did get in the mail last week, I haven't studied it, a version for 2020, which, because it was a COVID year, the statistics are not as complete as they would be in a typical year, which 2019 was. So what types of violations of the rules do we see the most complaints concerning? This shouldn't surprise you at all. I hope it doesn't. Number one for the past 18 years that I've been involved is Rule 1.4, the rule on communication, right? A client wants to hear from their lawyer about their case. They want to know what's going on. They want to know what's going to happen and when. When a lawyer doesn't return a phone call, when a lawyer doesn't consider the client their number one priority, the client is going to lash out and file a complaint. Again, this should be nothing new to any of us. It should be a reminder that not only do we need to communicate reasonably to our clients, with our clients, not only do we need to get back to them when they have a specific question in a reasonable period of time, and I would say a reasonable period of time is 24 hours. I think that's what I was taught in law school. That's certainly been my practice. And if I can't return it, I'm going to have my paralegal or my legal assistant call the clients and let them know that I will be in touch when I can be in touch if I'm otherwise occupied with another matter. Number two on the hit parade is diligence, right? Client doesn't see anything going on. Client wants to know, when's my case going to be heard? Why is the court system backed up? How come the judge hasn't written his or her ruling yet? Why aren't you doing anything to help me? My lawyer, who I paid a large retainer to. Diligence is always number two, right behind communication. How can you prevent that? You can prevent that with good upfront communication, with good upfront retainer agreements that lets the client know what to expect. Lets the client know what to expect by way of communication from you and with you. Lets the client know what to expect by virtue of the legal system, by virtue of how a case or controversy plays out in relation to the time considerations. There's a lot of frustration right now with COVID, right? The court system is backed up, but the client's problem isn't going away. And the best way I know to prevent a complaint against you is for you to have good, regular, level setting with the client upfront, good, continuous communication. Let the client know what's going on. Don't keep them in the dark. Don't assume that they're going to understand why things are taking so long or why you aren't getting their problem resolved quicker. Help them understand. Help them understand that up front. Help them understand that in writing. If we could all do that, you can see that represents 625 of the 763 complaints that were opened in 2019. Rule issues that concern primarily clients who are the ones most likely to file a complaint against you. Other things are, here, dishonesty, fraud, deceit, misrepresentation. A lot of that has to do with money, has to do with what you charge when you take money from your client trust account and move it over as an earned fee over to your operating account, the safekeeping of property with regard to settlement amounts, how much you are to get, how much they're going to get. Sometimes there's complaints about issues of fees. Again, because the client really was never given a good explanation up front or at the end of the case when money was being distributed, why they get what they get, why you get what you get, why doctors or other lien holders get what they get. Again, better communication will help avoid the most common types of complaints against lawyers. So, what areas of practice receive the most complaints? These are the top three. They've been the top three in the past 18 years. This is the only year, though, that we saw criminal area of practice have the most complaints with regard to it. It's usually domestic is number one. And I did peek at 2020 and it's reversed again. Domestic is on top, followed by criminal and tort complaints. So what is it about domestic? What is it about criminal law? What is it about personal injury law? I think Ann and Carrie covered it with a great set of words during their presentation, at least with regard to the domestic practice. There's a galaxy of issues in the domestic practice. You've got high emotion issues, right? Child custody. I heard asset evaluation, support payments. There's going to be a winner and there's going to be a loser most of the time, right? The loser, the one who ends up paying more than they feel that they owe, or perhaps getting less of a division of property, or not getting what they feel was appropriate with regard to custody. They're going to be upset. They've paid a lot of money to you to come out a winner. And if they don't feel that they have won, they're going to be very frustrated and they're going to lash out. You may be the attorney of the client. That client lashes out, or you could be on the other end of a complaint by the opposing client who's upset with how you handled yourself because the other clients, perceives themselves as having lost in the domestic area, the domestic issue, and they're going to file a complaint. So we get lots and lots of complaints in this area. Again, emotions run high. The issues they're life and death, right? At least in the eyes of the clients, they're life and death. They spent a lot of money on you, and they're going to be sharing their money, so to speak, with their ex, soon to be, and it's just an area that's ripe for frustration. Same goes for criminal law. It's usually an upfront payment to the criminal lawyer. Sometimes in the serious cases, the client or the client's family ends up mortgaging their house to pay the lawyer's retainer. And they only hear what they want to hear. They go to an attorney because they think the attorney can get them off or can get them a great deal. They're going to try the case and they're going to, in Perry Mason-like style, pull this one out and they're going to win. Well, that's not the way it goes in criminal law. Most of the cases are plea bargains, and those plea bargains can involve jail time. And what is a client who is sitting in jail going to do but think about how his or her lawyer allowed this to happen in their eyes? How did they not win this case for me? Why was I forced, or why was I coerced in their mind? to sign a plea agreement, and they lash out and they file a complaint against their attorney, claiming things such as, my lawyer didn't argue this issue, which I thought was important, or my lawyer didn't show up this one time to a status hearing, or I thought that the chief partner in that criminal defense firm was going to argue my case, yet it was some associate that ended up arguing the case. Lots of opportunity for a frustrated client, or now former client, to lash out at the one that they think didn't do the job that they expected, or really that they hoped for, and they find themselves hurt, they find themselves frustrated, and they file a complaint against their lawyer. The final area of practice is torts. Again, for similar reasons, it's usually the client of the attorney who feels that they didn't get as much money as they deserved, or they're being forced into a settlement, or coerced, or led to a settlement that they feel isn't fair, isn't enough. They don't think their lawyer has courage or the desire to fight for them. And although they do end up signing a settlement agreement, they're very frustrated and they think they were deceived, and they often file complaints against their lawyers. So none of that should come as a surprise to you. That's what the statistics show. And as I said, they show it every year. And I think it has a lot to do with the emotional state and the financial issues involved in the criminal, domestic, and tort areas. And unfortunately, the lawyers bear the brunt of that. Just because there's a complaint does not mean there's a violation by any stretch of the imagination. Your regional disciplinary committees are composed of fellow lawyers like yourselves who understand the practice areas. And although they do understand client frustrations, they understand that frustrations are different than a lawyer violating the rule. And it usually takes something significant for the panel to find probable cause. But those are the areas of practice, and I'm sure all of you who are involved in those areas of practice have received a complaint or two, and hopefully it hasn't gone too bad for you. But that, again, this is just how the statistics work out. And I think I've done my best to explain why. Final topic that I want to kind of bring this all together in terms of why certain lawyers receive complaints, what types of practice areas, what type of office practice is most common in terms of receiving complaints. We call this tips from the OCDC. This is some quotations from some of our disciplinary hearing members that consider lawyer complaints as part of their duties. I don't know why I'm not moving forward. There we go. Here's the first quote from one of the, we do have lawyer members and we have a couple of non-lawyer members on each committee. This was an astute observation by a non-lawyer committee member. She says, most problems I see are with small firms. Too many hats to wear: accounting, marketing, personnel management, administration, and oh yeah, legal work. Plus, these small law firm practitioners are likely to take on specialized fields of representation because they need the work, even though they may not be proficient. This non-lawyer member is very observant. Although we do not keep statistics on whether lawyers who receive complaints are solo practitioners, are with small firms, or are with larger firms, I can tell you anecdotally that the vast majority of lawyers who have complaints pending against them are with small firms or are solo practitioners. And just for these reasons that she points out, that they're concerned about their business and the issues of their business, and they may not be attuned to the actual legal work, at least to the point of good communication, of good diligence, of proper handling of money. They don't have the benefit of a big firm. I mean, a big firm usually has an ethics department. A big firm has mentors to go to before a matter gets to the point where a client is so frustrated that they may see a complaint. So yes, this is a tip from one of our non-lawyer committee members that a small firm lawyer needs to be paying attention to their legal practice and needs to figure out how to handle those other matters so that they don't interfere with the duty that they owe to their client. Legal work performed by attorneys without experience in a highly specialized field, like immigration, ERISA, or bankruptcy, resulting in missed deadlines, failures to satisfy conditions precedent, or required procedures and/or waiver of claims or defenses. This goes right to the small law firm practice. You're taking in a case that has to do with something that you're not completely proficient in. When you find yourself in a situation like that, it's time to associate yourself with a lawyer, another lawyer, perhaps another law firm, to help you to become competent in that area of expertise. That's a good way out, other than you spending the time to get competent in an area and maybe missing something. Associating yourself with a practitioner who is an expert in that specialized field is a great way to becoming competent if you are not competent because you don't have the resources of a larger law firm to assist you in that specialized practice. Another thing we see in the solo and small firm issues is the whistleblowing law office staff member, right? In a small office, that staff member, paralegal, legal assistant, they're going to be involved in your entire practice. They're going to know how the money flows through the practice. They're going to hear, they're going to see frustrated clients. And we, not uncommonly, will get a complaint by the now former employee of yours who will let us know that you have an issue with money, or you have an issue with client communication or other ethical issues. And that can be the source of an ethics complaint, which is pretty interesting. Again, we don't see this that often from the larger firm lawyers. Again, in the larger firms, you've got policies, you've got procedures, you've got mentors, you've got ethics, an ethics department or ethics lawyers that you can go to before things get so bad that there's going to be a complaint either by a disgruntled client or by someone who's going to become a former employee that you don't get along with. These are the rules, just kind of a recap of what I've discussed, of the common rules that are involved, particularly for the solo and small firm lawyers that receive complaints. We talked about diligence and communication. We talked about the handling of money, trust accounts. I touched a little bit on competence, but that goes right to the specialized areas of the law that you may not be completely familiar with, That's Rule 1.1. You have a duty to be competent in any area of the law in which you are going to engage. You can get that competence through looking up the law, through self-study, through consulting with someone else. But again, I think the recommendation would be is if you've got a high value matter in a complicated, specialized field, and you don't know that area, the best solution is to affiliate or associate with someone who does. And as I spoke before, the other rules in these small firms has to do with not properly supervising, whether it's an associate, a single associate, or not properly supervising a non-lawyer assistant. Again, if you're not teaching your staff about issues such as client confidentiality, helping with client communication, helping keeping clients updated. Not only are you possibly in violation of diligence and communication issues, but you could also be in violation of your supervisory responsibilities with respect to your lawyers and non-lawyer assistants. Again, this is just a summary. For matters outside your expertise, consider referring the matter out or entering a co-counsel arrangement. Never be afraid to ask for help or guidance. And take some time, slow down, and take the time to assess and audit your practice. Another lawyer committee member has said, I think very good attorneys are skirting ethical lines not out of a bad faith or intent, but simply because they're not taking a breath and thinking about what they are doing or what is going on in their office. That's a good observation. Remember that negligence, overwork, or sloppiness do not excuse ethical breaches or misconduct. So it may be time to hire more people, become associated or of counsel with another firm. Those types of strategies may be something that you need to consider if you're finding these issues that I'm talking about pertaining to you. Attorneys should spend more time with their letters of engagement. These are all too often an afterthought, and when they are poorly drafted or non-existent, we see problems with clients and attorney expectations. This is another observation by a non-lawyer committee member. Interestingly, and this may not be your practice, but there's a lot of practice areas that do not require a written letter of engagement. In my opinion, that's a shame. Every lawyer should have a letter of engagement with every client so that you can set expectations with the client, so that you can be clear with the client what you're going to do and what you're not going to do. Here's some examples that a good retention letter, a good attorney-client agreement could have avoided a complaint. An attorney handles a criminal matter for a flat fee, and additional charges are filed against that client, or the charges are upgraded. The attorney says, well, you hired me to help you with the larceny case. Your fee doesn't cover these new charges or this upgrade from a second level felony to a first level felony. That issue could have been avoided. That frustration could have been avoided. That complaint could have been avoided had that agreement to represent that criminal defendant been in writing. But there are a number of criminal defense attorneys who don't use a fee agreement, and they often find themselves on the other end of an ethics complaint because the client assumed that the lawyer was going to defend everything that arose out of whatever it is the client did, and are upset to learn that they have to now come up with even more money to pay you when they weren't expecting it. Post-conviction relief. After a plea of guilty, the client wants help. Perhaps they feel that the judge coerced them into accepting the plea, or perhaps there's some new evidence that came forward that neither the attorney knew about or the client knew about, and the client now wants to seek post-conviction relief, and they want you to do it. And if they expect you to do it, right? You're their criminal defense lawyer. Well, most lawyers would say in response to that, I was just hired to defend you. I wasn't hired to handle any appeal or post-conviction relief. Again, if you don't have a retention agreement and you aren't clear with what you're doing, the client may assume otherwise, and that could result in an ethics complaint. Here's another example. Attorney handles a flat fee divorce and the case is settled and a judgment entered, but later the opposing party moves to modify custody, child support, a parenting plan. The client gets angry when the attorney requests an additional fee. I can understand that. Or an attorney agrees to handle a contingency fee case for a pre-existing client who is used to paying hourly rates. Confusion occurs when a case is settled and the attorney takes her fee. Well, in contingency fee cases, those have to be in writing, but you need to take the time to actually explain what the contingency fee case is and who's going to get what and how that's going to be determined. Clients get particularly upset when unpaid medical bills come to light after the case has been settled and all proceeds have been paid, and they want to know how come the attorney hadn't taken care of those unpaid medical expenses when they took the case and when they helped settle the case. Again, that should all be covered in a good contingency fee written engagement letter and an explanation with the client upfront and during the case, and finally at the settlement stage. They should understand and have full knowledge of exactly where the money is going and why. Another example of where clients get upset because there's not a written agreement up front is a case is settled on the courthouse steps or in chambers. The attorney is going back and forth negotiating with opposing counsel and advising her client. Later, after the judgment is entered, the client claims not to have understood or not agreed to certain terms in the settlement, right? They see you going out of their vision back to the judge's chambers, having conversations that they aren't part of, and you come back and you say, okay, we've got it done, but they don't understand exactly what all of those terms are, and then they get this written proposed or consent judgment or agreement shoved in front of them with the instruction to sign here, or this is our only chance, or this is our best chance. And they're put under a tremendous amount of pressure to agree to something where they don't quite know how that agreement was reached or why it was reached or what bargaining went on. And they feel compelled to take the deal because their attorney, who they trust, is telling them that this needs to be signed or this needs to be done. Again, keeping the client informed, laying out the expectations in writing as part of the retention agreement could avoid some of the frustration and could avoid a complaint down the road. Where to get some help for a good scope of representation agreement? Take a look at the comments to Rule 1.2C. It's a great check the box list of those types of essential activities that a lawyer normally engages in for a client. And you can print that out or make it an addendum to a written fee agreement, and the client will understand because they'll see the boxes checked about what they can expect from you. And they can see such things that aren't checked, such as post-conviction appeals or post-judgment requests for modification in your domestic practice matters. Again, Rule 1.2C is a terrific resource, a terrific way of helping you draft your retention agreements so that you don't run into an issue of a frustrated client which all could have been avoided had you set the expectations up front. Again, this just emphasizes that 1.2 has the good checklist, and only the legal services that are checked off are what you are going to provide. And it's a much simpler way to help your client understand exactly what you're going to do and what you're not going to do. Settlement statements at the conclusion of your case is also an opportunity to lay out all of the bills, all of the liens, all of the people who are going to be paid out of the settlement proceeds. Have a disclaimer stating that this is all the known obligations and that you and your firm are not going to be liable for any outstanding bills or obligations discovered after the fact. And finally, any courthouse settlements that I talked about, you make a record that day. You perhaps put your clients under oath and ask them questions. Do they understand that this is what they agree to? And the judge can help be an extra check on certain matters if you sense that your client is not understanding what it is that they are going to agree to. That's it, Rob. What questions do you have?
Mark, that was fantastic. Great practical tips, certainly at the end, the survey of a couple of the cases and the statistics. We're all fortunate to have you and your experience share these things with us today. We appreciate it. A couple other final things, folks. Remember the next program, Thursday, November 18. We'll have that in the morning, covering a survey of civil cases in the past year by Steve Ringkamp, Bob Wallace, Hal Welford talking about sports law, and then we'll have another ethics program. I want to thank everyone for attending and especially supporting the nonprofits that we're supporting with the funds that you've all provided to attend. Legal Services of Eastern Missouri, Beyond Housing, and the St. Louis Mediation Project will be the beneficiaries of the proceeds of this program. And again, we thank all of you for attending and wish you a wonderful weekend. We'll see you November 18. Bye now.